All right, ladies and gentlemen, this is Professor Brenton Boyce, and this is Courtroom Testimony, CRJS260. And I'm going to be lecturing now on Crawford v. Washington and the Hearsay Rule. So let's go ahead and jump into it. I know I've talked to you guys before about what the Hearsay Rule means, and I'll go over it again. By definition, hearsay, by rule, hearsay evidence is not allowed and is inadmissible in court unless it falls under an exception to the rule. So there's a list of exceptions. We're not going to go over all that. What now? You know that's the general rule. Now, what is hearsay by definition? Hearsay is an out-of-court statement made by a declarant or person that's not in court and not available to testify. So not just not in court, but also not available to testify. And that statement that person made is being offered to prove the truth of what they said. So what it is let's say a person has witnessed something, and they give a statement or they say something to someone else, and then they're not available, but the person they said it to is now available, and they come to court just to testify to what that person said. But the person that said it is not available in court. So now that person is not available, even if they are available to come to court, they may be of a certain status where they can't be forced to testify because of some type of privilege, and we'll talk about that when we get to the Crawford case. So in that situation, that is hearsay, depending on why it's offered. If it's offered to prove the truth of the statement that's made, then it is hearsay. If they're not offering the statement or the testimony to prove the truth of the statement, but to prove something else, then it's not hearsay. So as I said before, hearsay is a two-pronged test, or two-pronged definition. Out-of-court statement made by someone that's not available to testify, or not physically available to testify, or not, or well, let me say it again. They're not physically there to testify, or they can't be made to testify. In other words, so you can't force them to testify because of some type of privilege. And then two, the statement they make is being offered to prove the truth of the statement they make. So the statement they made is substantive to the case, and the statement is being offered to prove that what they said is true. That is hearsay. Now, if it's being offered for some other reason, like it's in another setting, I think I gave in another lecture, my Melendez-Diaz lecture, I gave the Biggie, the Lil' Kim, Mary J. Blige Biggie story, to describe someone giving a statement or saying something to someone else, and someone else taking it and then having to come to court and say what they said. So it depends on why it's offered as well. So Crawford v. Washington. Of course, it was a case, a 2004 case. It was argued in 2003, but decided in March of 2004. So that's when the ruling came down. Crawford v. Washington is a United States Supreme Court decision that reformulated the standard for determining when the admission of hearsay statements in criminal cases is permitted under the Confrontation Clause of the Sixth Amendment. The court held that cross-examination is required to admit prior testimonial statements of witnesses who have since become unavailable. Background: Michael Crawford and his wife Sylvia Crawford confronted Kenneth Lee over an allegation that Lee had attempted to rape Mrs. Crawford. Michael Crawford stabbed Lee in the torso. Crawford claimed that he acted in self-defense when he believed Lee picked up a weapon. Lee denied doing anything that might make Crawford believe he was trying to attack him. Both Mr. and Mrs. Crawford were questioned by the police after receiving a Miranda warning. Mr. Crawford said to the police that he was not sure if Mr. Lee had a weapon, but that Crawford believed that at the time. Mr. Crawford said to the police that he was not sure if Mr. Lee had a weapon, but that Crawford believed that at the time that Lee did. Miss Crawford, being interrogated separately, at first said that she had not seen the attack, but under further questioning said that she had seen the attack and that Lee was not holding a weapon. At trial, Ms. Crawford could not be compelled to testify by the state since under Washington's spousal privilege, a spouse cannot testify in court without the defendant spouse's consent. So that's what we call spousal privilege. So if so what that says, and it doesn't apply in every state, but it applied in the state of Washington. If you're married to someone and they can't force that person to testify against you without your consent. So if you don't want your wife to testify against you, even if she wants to testify against you, she can't testify against you. So they can't do it without the consent. So of course, in this situation, why would he give that consent? Of course, so she wasn't like physically unavailable. It's not like she couldn't show up to court. She was technically unavailable because there was a spousal privilege. So she was unavailable because they couldn't make her. She couldn't testify. Literally, the law says there's a spousal privilege, and we don't make spouses testify against their spouse. So it kind of is what it is in that situation. She can't testify, so she's technically unavailable. So the deputy prosecutor, Robert Lund, sought to introduce Ms. Crawford's statement to the police as evidence that Crawford had no reasonable belief that he was in danger from Mr. Lee. Generally, out-of-court statements by persons other than the accused are excluded as hearsay. Here, the court allowed the statement to be admitted on the basis that the statement was reliable, as it was partially corroborated by Mr. Crawford's statement to the police. Because remember, he said something about being unsure about the weapon. Talk too much. That's why you need to be quiet. Don't talk when the cops interrogate you. Say, I'm waiting on my lawyer. But the defense counsel objected to the admission to the wife's statement on the ground that Mr. Crawford would be unavailable to confront Ms. Crawford on her statement without waiving spousal privilege, and that this would be a violation of the Confrontation Clause of the Sixth Amendment. The statement was allowed into evidence at trial, and the prosecution relied on it heavily in its closing argument. Michael Crawford was eventually convicted. The Washington Court of Appeals overturned the decision of the trial court after applying a 9-factor test to determine whether Sylvia's statement was reliable and therefore admissible under the doctrine of Ohio v. Roberts. The court determined it was not and gave several reasons why. However, the Washington Supreme Court reinstated the conviction, ruling that the witness's statement was reliable under Roberts. In particular, the court noted that Michael and Sylvia Crawford's statements interlocked and therefore concluded that Sylvia's statements were admissible. The United States Supreme Court decided to hear this case because, once again, it was even though it came out of the state, they decided to hear the case because it was a question of federal constitutional law, so they decided to hear it. Okay, so the overall ruling of the case. Let's see here. The court ruled that the use at trial of an out-of-court statement made to police by an unavailable witness violated a criminal defendant's Sixth Amendment right to confront witnesses against him. So they essentially ruled against the Washington State Supreme Court, and they said, no, that's unconstitutional. You can't, because she's unavailable and can't be made to testify, it doesn't matter how reliable her statement is, it's not coming in. So it didn't fall under a hearsay exception, so it's not coming in. Let's talk about the decision and rationale. The United States Supreme Court held that the use of the spouse's recorded statement made during police interrogation violated the defendant's Sixth Amendment right to be confronted with the witnesses against the defendant, where the spouse, because of the state law marital privilege, did not testify at trial and was unavailable. Associate Justice Scalia, writing for the majority, expressed concern over the inconsistent results reached by courts under the Ohio v. Roberts standard used by the Washington state courts. He thought the results of the Crawford decisions at various levels of Washington state courts was exemplary of this problem. Justice Scalia gave a thorough history of the Confrontation Clause, explaining how the clause became part of the Constitution using famous English cases such as that of Sir Walter Raleigh. He then described the context in which the constitutional framers drafted the clause. He displayed how early American courts interpreted the clause. This history, Scalia concluded, clearly shows that the Confrontation Clause was directed at keeping ex parte or one-sided examinations out of the evidentiary record. In other words, it had to be fair and you had to be able to cross-examine it. Specifically, the Confrontation Clause applies to witnesses against the accused, meaning those who bear testimony. Relying on this and the historical record, Scalia stated that the framers would not have allowed the admission of testimonial statements of a witness who did not appear at trial unless he was unavailable to testify and the defendant had had a prior opportunity for cross-examination. Scalia determined that a prior opportunity for cross-examination was mandatory and dispositive of whether or not, and that dispositive means final, of whether or not testimonial statements of an unavailable witness are admissible. Testimonial statements are formal declarations, those made to i.e., that is to say, those made to law enforcement or government personnel. So, because she made the statement in a interrogation setting to law enforcement, it classifies as being what they call a testimonial. So, dispensing with confrontation because testimony is obviously reliable is akin to dispensing with jury trial because the defendant is obviously guilty. What he means by that is the right is the right. It doesn't matter how reliable the evidence is. It's still, because of the Sixth Amendment Confrontation Clause, is not allowed. So I want you to know there's a difference between the hearsay rule and the Confrontation Clause. Now, the hearsay rule is what it is, but the Confrontation Clause is kind of joined with hearsay in situations where it robs a defendant from the ability to essentially confront and cross-examine witnesses against him or her. So in this situation, with other hearsay that doesn't fall under that Sixth Amendment violation, sometimes stuff can get in because it's reliable. Like, there's one exception to the hearsay rule is dying declaration. So someone gives a statement on their impending death. They're about to die, last breath, and they say, Biggie did it, or something like that. In that situation, whoever heard him say Biggie did it, and they say, well, before he died, he said Biggie did it. That is allowed only because, in that situation, it probably wouldn't be allowed because it once again may violate the Sixth Amendment. But if it's being offered in some other situation where it's not, even though it's been offered to prove the truth of the matter asserted, but it may not be offered in a situation where it's going to violate a constitutional right, it may be allowed because of the reliability. So the only thing that rebuts the hearsay rule in most of the situations where hearsay is allowed as an exception, the hearsay is reliability. Like another what would be hearsay that's allowed is what they call regularly conducted records that are normally conducted or saved. So in everyday business. So let's say, like with the city, when the parking tickets and stuff like that, that's a regularly conducted. They keep up with that stuff as records. It's city records, a public record, and they keep up with it. And there's a chain of custody and the way they do things. So a document from the city saying that this person was here or there at this time would be allowed because of the reliability of it. Because, essentially you don't have to have a person from the city come and testify to what it is because it's a regularly kept record. So that was one of the exceptions. Now, that's not the exact verbiage, but so most exceptions of the hearsay rule are based on reliability. But in this case, in cases where it's going to go against someone's Sixth Amendment right, essentially what the court says is it doesn't matter how reliable it is. That person has a right to confront that witness, and if that witness can't be made to testify or they're unavailable, then we're not allowed it. So you can convict them, but you got to convict them some other way. So that is the Crawford case. So that's what happened. So so they granted, and let's see. So they essentially overturned his conviction. So in other words, it would have had to have a new trial where now that statement can no longer get in. So depending on how definite that statement is, either they would have dismissed the case, and I didn't read the let me see the rest of the history discussion. Okay, let me read the rest of it. The Crawford court determined that where non-testimonial statements are involved, the confrontation clause allows a court to use its discretion. So if it's non-confrontational, meaning a statement not given to police, the courts are allowed to use discretion to determine the reliability of the statements. Where testimonial evidence is at issue, however, the Sixth Amendment demands what the common law required: unavailable and prior opportunity for cross-examination. So without there being a prior opportunity, the person's unavailable and the other person didn't have a prior opportunity and didn't get to cross-examine them even before trial or have the opportunity, then it doesn't come in. The only indicium, or that means indication of reliability sufficient to satisfy constitutional demands, is the one the Constitution actually prescribes, and that's confrontation. So in other words, if the person can't confront the person, it's not coming in. Essentially, is what that said. So this applied to only testimonial statements. So statements given to law enforcement formally in an interrogation. That's deemed to be testimonial. So even in other situations, it's probably not going to come in because it's going to violate the Sixth Amendment right. So, and I can't think of anything that would be more reliable than that. So what someone says on the street corner to somebody is different. It was not. I wouldn't see that as being reliable as law enforcement coming in saying we did a interrogation. So that was the ruling of the court. So that explained that is hearsay that's not just hearsay, and you know what hearsay is, but that's hearsay in practical application in cases, and how if hearsay is allowed, not only is it unfair because I don't get the opportunity to question this person, but it's also unfair because now you have a Sixth Amendment right to confront this person. So it's going to be violative of your Sixth Amendment right, specifically if you're a defendant. So that is the Crawford case. Definitely read the case. Read what I provided for you in full. I've given you an understanding of the hearsay rule and how it applied in both cases. How the only reason that statement is hearsay is because they couldn't make the wife testify because she was unavailable because their own state, the state has a spousal privilege where a spouse can't testify against another spouse unless that spouse gives them consent to testify against them, and who would do that? So pretty much if you're married to someone, you're not testifying against them unless they say it's cool, and they're not going to say it's cool. So that means she was technically, even though she was there living and breathing and could probably sitting in court, they still couldn't make her testify because of that privilege. So read the case that I provided for you, the documents, learn, kind of become familiar with it, and I think listening to this lecture would probably help a lot as well, and you'll probably be prepared for whatever questions I give on a final or whatever once you're questioned about this. So take care.